Okay. I guess everybody's not too interested. I know you guys will be though. I'm shocked. Not shocked. Well, I guess I am shocked. I'm shocked that um this new defense is taken up for him. It kind of threw me for a loop because I wasn't expecting them to really do hardly anything. Uh, but they are. So there's this new filing. Kara was like, "Did anybody see the new filing?" And I was like, "What filing?" Because I thought they were going to wait until after the Supreme Court, and they didn't. Um, Thankfully, the clerk is nice enough to be quick these days. So I'm going to pull up this filing and we're going to read it. Let me see. I wonder if did anybody read it yet? I want to make this kind of short, just read it. We can talk later. Sorry, I know I'm taking forever. All right, Google Drive, Delphi. Okay, so this is the motion to transfer Richard Allen, and it says, now comes the defendant, by and through his appointed counsel, Robert Scremin and William Libredo, and hereby submits this motion to transfer and state as follows. Richard Allen is currently being held in pretrial detention at the Wabash Correctional Facility, a maximum security state prison. After visiting with Mr. Allen at both the Westville Correctional Facility and the Wabash Valley Correctional Facility, it is counsel's belief that one, Mr. Allen is not being treated similar to other pretrial detainees being held in county jails, and two, pretrial incarceration at Wabash Valley Correctional Facility will seriously, if not fatally, impact counsel's ability to effectively represent Mr. Allen due to the distance of travel and visitation conditions. On November 3rd, these are the facts that they list here. On November 3rd, 2022, the state of Indiana filed a motion on behalf of the sheriff of Carroll County asking the court to transfer Richard Allen to the custody of the Department of Corrections, claiming that due to this being a high-profile case, the Carroll County Sheriff could not adequately provide Mr. Allen with necessary security or other needs at the Carroll County Jail. Judge Diener, without holding an evidentiary hearing on the merits, granted the state's motion and approved Richard Allen's transfer to the Department of Corrections, then recused himself from the case that same day. Mr. Allen had no opportunity to object to this transfer, and no one appeared to consider how this might negatively impact Mr. Allen's defense. On April 5th, 2023, Mr. Allen's former counsel filed an emergency motion to modify safekeeping order, essentially a motion to transfer Mr. Allen to a county jail. I have reviewed counsel's motion, and although I lack personal knowledge to vouch for all of the allegations made, as Mr. Allen's present counsel, I believe it to be a meritorious motion, and based on 25 years of practicing law, I agree that Mr. Allen is not being treated similar to other pretrial detainees in county jails, and that his pretrial incarceration at a distant state prison severely impacts counsel's ability to effectively communicate with Mr. Allen and effectively represent him. I would incorporate the legal arguments made by prior counsel and add that Mr. Allen's distance from present counsel and the conditions during visitation negatively impact counsel's ability to effectively represent Mr. Allen. On April 14th, 2023, this court denied prior counsel's motion, and Mr. Allen remains in the custody of the Department of Corrections. On April 28th, 2023, this court received a letter written by an inmate at Westville Correctional Facility alleging that Mr. Allen was being abused and mistreated. On September 18th, 2023, prior counsel filed a motion for a Franks hearing in support of their previously filed motion to suppress. Prior counsel included a 136-page memorandum with 126 confidential exhibits. The memorandum and exhibits, among other things, allege prison guards at Westville Correctional Facility were allowed to wear patches on their official uniforms supporting Odinism, and that crime scene photos suggested a potential connection to Odinism, a Nordic religion and or cult that has been associated both in the prison system and in society in general with white supremacy. After reviewing crime scene photos and visiting Mr. Allen at Westville Correctional Facility, present counsel believes these claims have merit and that pretrial incarceration within the state prison system negatively impacts Mr. Allen's rights in addition to counsel's ability to effectively represent him. On October 27th, 2023, this court appointed attorneys Robert C. Scremin and William Libredo to represent Richard Allen. Attorneys Scremin and Libredo both reside and maintain primary offices in Fort Wayne, Allen County, Indiana. Fort Wayne is approximately 106 miles from Westville Correctional Facility and a 2-hour drive. Fort Wayne is approximately 233 miles from Wabash Correctional Facility and approximately a 3.5-hour drive without stops. Counsel's most recent visit to Mr. Allen at Wabash Valley Correctional Facility was a 10-hour day. On November 19th, 2023, counsel visited with Mr. Allen at Westville Correctional Facility. The visit was an arduous process which included lengthy travel, complicated and protracted prison security procedures, and difficult visitation conditions. Throughout our legal consultation, Mr. Allen remained uncomfortably and unnecessarily shackled and chained in a manner resembling Hannibal Lecter, while guards watched through glass panels and the door ajar. Mr. Allen clearly appeared intimidated by the guards and was hesitant to speak freely with counsel. And they attached an exhibit, Exhibit 1, which is an affidavit of their investigator, S. Mahler. Although none of the prison guards were wearing patches in support of Odinism, one of the guards did have a symbolic face tattoo of Odin's spear and multiple hand and finger tattoos and emblematic of Odinism and or Norse mythology. This same prison guard had a public Facebook account that also displayed the same tattoos in addition to a necklace with Thor's hammer inscribed with the letters BRSRCR, an acronym for Berserker, which is a very specific type of Norse battle axe, and the name given to warriors fighting in honor of Odin. Other photos displayed 3 interlocking triangles, another symbol associated with Odinism. Mr. Allen stated that Westville guards were intimidating and reluctant to provide him with shower and recreational access because it caused them extra work, and as a result, he often simply remained in his cell and went without recreational time or a shower to keep the peace. On December 22nd, 2023, Counsel visited Mr. Allen at Wabash Valley Correctional Facility, where Mr. Allen had recently been moved without consulting counsel. The round-trip drive and visit took over 10 hours to complete. Access to the prison once again took nearly an hour, and several gates had to be manually cranked open as there was a power outage in a portion of the prison and doors could not be opened. Prison staff indicated they did not have any type of visitation rooms for counsel to use because they, quote, were not equipped for such matters, end quote, but had fashioned a visitation room in some sort of prep kitchen within the prison housing unit. Counsel was informed the visitation would be monitored by video camera. Counsel was taken to Mr. Allen, who was locked in a prison cell located within the kitchen. The cell appeared to be designed as a place to feed a prisoner. The cell had a solid iron door with a small hinged iron flap approximately 8 inches high that opened just far enough to slide a food tray through. This iron flap was left open, and it was through this small opening that we were allowed to see Mr. Allen and speak with him. A folding table was set up approximately 6 feet from the cell door and 3 chairs on the far side of the table. We were instructed to sit in the chairs and not to approach Mr. Allen or come within 6 feet of the cell door. This arrangement made it impossible to show Mr. Allen any videos or documents or to discuss the case with him without raising our voices and almost shouting. In 25 years of practicing law in 5 states, including representing numerous defendants charged with murder, I have never had to conduct an in-custody legal consultation in this fashion. The prison's visitation arrangement created an environment wherein effectively representing Mr. Allen was a fiction. Mr. Allen stated that in the 2 weeks that he had been at Wabash Valley Correctional Facility, he had not received or even been offered any recreational time, and he believed he had taken 1, possibly 2 showers, and he had not been allowed outside in the prison yard, although other inmates enjoyed outdoor recreation. Conclusion. In 25 years of practicing law, I have never had to conduct an in-custody legal visit in the manner I have with Mr. Allen. I routinely conduct legal visits within the jails in Allen, Adams, Huntington, Randolph, and Wells counties, including consultations with numerous clients charged with murder. There is never a guard present during the consultation, and there is never audio or video equipment recording the visit. My clients are never shackled, handcuffed, or chained during visits. These are clearly state prison policies, not county jail policies. I am often able to simply sit at a table with my client and have a conversation, but at the very least, I am able to sit directly across from my client and speak through a large plexiglass partition where we can view videos and documents. County jails routinely, dare I say daily, have lawyers visiting pretrial detainees, and as such, county jails have rooms specifically designed for attorney visits. County jails also have a streamlined access protocol for defense attorneys that often takes no more than a minute or 2, as opposed to an hour, and laptops, phones, and tablets are routinely allowed during attorney visits with no special requests. County jail visits with clients can even be set up the same day. Clients in county jails are extremely accessible, and multiple visits can be quickly and efficiently made when legal issues arise. Based upon counsel's observations and experience, Mr. Allen is not being treated similar to other pretrial detainees being held in county jails. However, even if this court were to find that Mr. Allen's pretrial treatment within the state prison system does not in itself justify moving him to a county jail, evidence is absolutely overwhelming that pretrial detainment at Wabash Valley Correctional Facility will seriously, if not fatally, impact counsel's ability to effectively represent Mr. Allen due to the sheer distance of travel and the unworkable visitation conditions. Counsel for Mr. Allen respectfully requests that he be transferred either to the Allen County Jail or the Adams County Jail. And it's signed by Robert Scrimmen. So I honestly didn't expect them to, I don't know, like I mean, now we know our answer about if they're going to take up the Franks hearing, because they clearly agree with it. And my my only concern with that is I'm just not sure how they're going to effectively argue that, considering the sheer volume of depositions and evidence. And uh I mean, those other folks went to Georgia to get stuff. I don't know. So, but we never heard about the guard with a face tattoo and all that extra shit about the, I probably said that name wrong, but all that extra stuff about all the pictures on his Facebook and whatnot. So, and they also confirmed that he seems intimidated. Hold on. So, I don't know what everybody's thinking, but I'm sure glad they spoke up. What would be really interesting is, after all this time and all these emergency motions and essentially begging for him to be moved and then called a liar. I mean, she literally has put, not only did Judge Gull say in a in-camera hearing that we have the transcript to, but then she wrote it in a filing that she sent to the Supreme Court, that the defense attorneys in their motions to have him transferred provided lies essentially to the court, that none of this was true. And I think it's good, especially now going into the arguments on the 18th. You have these brand new set of attorneys that are coming in, and they're essentially co-signing and agreeing with what was said, and that it's not safe. So I'm just appalled. I don't understand why uh or how anybody is okay with any of this, but apparently a lot of people are. um they just think that, and you know what's really crazy, like, I get to thinking about the people that say, oh, well, that's just the defense, they have to do that, they can basically lie and not get in trouble. Like, of course they're going to say that. He probably told them that because they want, the public to feel bad for him and things like that. And it's like, well, then how do you determine whether their accusations are legitimate or not? Like, if you're just automatically just brushing off accusations like this because you're of the opinion that a defense attorney is just going to outright lie to a court, then how do you know when they die? Like, is that how you know when they're actually telling the truth? Like, I just don't, I don't understand. It's worrisome. It shouldn't be for as easy as it was to send him to the Indiana Department of Corrections and throw him into the state prison system with no lawyer. It took a millisecond to do. Uh, I can't believe, it is frightening how difficult it is to get him out of there for as easy as it was to put him there. And I'm just saying, I can't imagine being arrested for something that I didn't do, but I certainly couldn't remember. I don't know what I would probably, I mean, the fact that he's even still alive, I'm sure I'm not the only person that's surprised he's still alive. I probably wouldn't be, as much as I would try to be, but we're not even just talking being in a state prison system for a year. We're talking about being in solitary confinement for a year. Someone that's simply been arrested. He's simply accused. He's their suspect. He's a suspect to the degree that they felt like they were so sure that he was the one that did it that they felt he needed to be arrested and have some accountability to not run and make sure he shows up at a court date when they uh because they're formally bringing charges. But like, it's just a step up from being really sure that my suspect, A, did it, and we keep bringing him in for interrogations, but he's not slipping up, so we can't really do anything, or we're trying to collect more evidence. It's literally just one step above that. And so I'm very concerned that not everyone's concerned with the fact that anybody can be arrested, have multiple attorneys saying, this is not right. This is not right. This is what's happening. This is what he looks like. This is what he's claiming. This is the evidence that we have. And basically just being brushed off and told to fuck off. And then being moved randomly with no prior warning to your attorneys, just picking you up out of your bunk in the middle of the night and taking you 3 hours away from your attorneys. And them having no clue that you've been moved. I don't know, man. I don't know. And making it so that you are no longer visible to people and to the public is how you get lost. In my opinion, this is just my opinion now, but Richard Allen was never expected to be alive at this point. Um, he's now creating additional issues. This isn't in my mind. This is what I perceive as what's going in their mind, is that he's now creating additional issues for the Indiana Department of Corrections because of all this attention that it is getting. Did anybody listen to I just want to say this, and I want everybody to kind of just sit with this for a little while with what I'm going to say and this filing, and then we can come back and talk about this at some point later because I have to go back for my lunch. But if anybody's watching the Jennifer Dulos trial, something that I really appreciated from that judge, they didn't do opening statements, which was a little bit strange, but what they did do was like a really extensive instruction, like jury instruction. So basically, the judge sat and explained like what different charges are, what they're supposed to consider, what they're not supposed to consider, what they're supposed to do when they leave every day, what they're not. So various things. And they don't usually, not every judge does it. And the ones that do don't always necessarily drag on like that. But I appreciated it, and I was very interested in what he was saying. And anyway, one of the things that struck me was at one point he said, if I were to ask you today what your opinion is on whether the defendant is innocent or guilty, the answer is not, I don't know. I don't know yet. I need to see more. He said the answer is that he's innocent, and that's the only way that we maintain the presumption of innocence. And I get that people say like, oh, but that's the jury, we're the public, like we're just looking, we're just watching, but the thing is that when you're constantly spreading this whole, well, as long as I'm not on the jury, like, then the presumption of innocence doesn't really matter, because the only place that that's necessary is when you're sitting on a jury inside of a courtroom once a case starts. But if you spread that thinking, that line of thinking, and everybody thinks that way, then automatically by the time that you end up at a trial in a jury, that's already your line of thinking. You're already thinking, well, you know, if we're there's like small bits of bias that you may not even think that you're thinking. Like uh something as simple as, well, he's arrested, so they think he did it. I'm not a law enforcement officer. They know more than I do. Um, but I was excited, not excited, but it was good to hear him say that. I don't think that I have heard it maybe phrased that way, but it struck a chord with me because I've seen that I don't know how many times a day all over the place where people demand to know whether you think someone's innocent or guilty. And it seems, I even do it myself. It seems that most people say, I don't know. I'm reserving my thoughts until trial once I see all the evidence. Um, he could be guilty, but he could be innocent. I'm not really convinced one way or the other. And the fact that hearing it from the judge specifically say the answer is not you don't know. The answer is that he's innocent was, I guess, powerful for me. I If I'd have heard it from a lawyer, it would have been a little bit different than it was coming from a judge. But thanks for coming and listening to this motion. It was a good motion. They didn't disappoint. I had very, very, very low hopes for this team. And so this one confessed. Okay, before we start seeing all the crazy shit, I'm going to go. We'll try to schedule another talk maybe tonight. I'll see when everybody, because I know Bob's going to want to talk about this. Probably Teresa too. I'll have to message her. But thanks everybody. Love you guys. I'll post on my Twitter page the actual link to the to the filing. All right, love you. Bye.